Okay, good morning, everyone. Welcome to this Employment Foresight webinar. I'm your host. My name is Ben Allery. I am the co-founder and CEO of a company called Blue Jay Legal, which is the company behind Employment Foresight, and a number of other AI software products, including Tax Foresight, that use AI to understand legal issues. Today, we're going to be focused specifically on the question of reasonable notice and how to figure out how much reasonable notice to give to an employee who's being terminated. And we're going to use Employment Foresight to basically illustrate how you can do this using AI. At the outset here, maybe what I should do is note one thing, which is that this program is pre-approved for CPD credit from the HRPA for an hour. We expect this to go for about an hour, and the plan this morning is to talk a little bit about the context to explain how and why using this kind of technology is now possible to predict reasonable notice periods, to talk a little bit about a real kind of scenario. So to make this really, really clear that the software is pretty easy to use and you can use it to solve real practical problems in the field. And it's one of the reasons why we've got dozens of organizations that have signed up to the software and are actually using it to inform themselves about what the law would require in various circumstances. And so we'll do a walkthrough of a real situation, how you might actually use Employment Foresight to conduct that research, that background research that would help you proceed with your termination situation more confidently. Okay. So that's kind of the plan. First, some context, then introduce a real kind of situation, and then walk through the software. And the idea is to give you a proper orientation to the software and everything that's going on. There is the ability to lodge questions here using the Q&A. And somebody has asked already, so good for you. You figured out how to use the Q&A system. Someone's asked whether the presentation slides will be available following the webinar. Yes, they will be, in the sense that we are posting the webinar. So this is being recorded. We'll post this recording afterwards, and you'll be able to access it from our website, bluejaylegal.com, after the webinar. So we'll do some post-processing of it, and then we'll clean it up and get it posted online. So welcome. This is the Employment Foresight webinar focusing on reasonable notice, and let's jump right into this here. All right, so let's get into this. What about the broader context? What's happening? What is Blue Jay Legal? We're a company based in Toronto. We have a team of lawyers, law professors, data scientists, and others who specialize in machine learning and analyzing the law. And we've got dozens of clients right across the country using our software to think more deeply about the legal issues that they're facing. And what I can tell you about the broader context is this really represents an evolution in how lawyers, other professionals, HR professionals, accountants with respect to our tax product are approaching researching various different kinds of legal questions. And historically, a lot of the materials were what I would describe as analog. So using books, right, to conduct research, leveraging libraries, law libraries, tax libraries to inform themselves. I mean, going way, way back, you can think about the Code of Hammurabi, which was, this basalt slab that was 7.5 feet tall, with various legal dictates carved into the slab of rock as analog legal technology. So we're talking a history going back centuries and centuries of analog technology where things are really embedded in physical materials that are then looked at, read as a reference material. Things started to change in the early 1970s, and a lot of legal research materials started to be digitized. So we had law libraries, legal materials, cases coming out of courts, hopping onto digital platforms. And sometime later into the 90s, things started to move on to CD-ROMs, and then a little bit later, things started to move into the cloud. Now, we see the advent of something new, which is the ability to leverage all of that digital data. So that digital data is now online, it's in digital format, and we can use that data and a lot of the computing power that is increasing exponentially to analyze that digital information to get new insights into what's actually going. Okay, so and that's what we're doing. That's what we think Employment Foresight does. That's what Blue Jay Legal is all about, is leveraging computing power and new algorithms, machine learning algorithms, to get insight into legal research problems. Okay, so how does this actually work? Well, a lot of lawyers are using our kind of software to provide clients with the highest quality legal advice, to double check their instincts on different situations. So if you are an employment lawyer, you go to see an employment law specialist. When you run into these kinds of issues, they often have a very good idea what the reasonable notice period ought to be in different circumstances. If you chat with them, they'll say, well, heuristically, my gut tells me it's likely to be X number of months or Y number of months. Sitting behind that advice is often years and years of experience and knowing what actually happens in settlement discussions when things actually go to court. One of the challenges for legal counsel, though, is it's very hard often to convince the other side that your instincts are actually correct. So one of the things that lawyers are doing with our software is getting an independent take on what the law actually requires and to be able to document that and substantiate that for the other side. So it's actually really, really helpful when you get to settlement discussions. And clients often really want to know from their lawyers what specifically is the right kind of notice period. Can you be more specific? One thing that lawyers don't like to do is to commit themselves too much to a very tight range. So they'll often give a fairly broad range and say, well, it could be anywhere from 8 to 18 months. So for example, I was in Alberta last week, Jasper, Alberta, doing a presentation to the benchers of the Law Society of Alberta on precisely this. So a version of this problem that you're about to see. And I asked them, so is anyone here an employment law specialist? And of course, some hands went up, and I asked, we presented the situation and asked, and I got a wide variety of answers in the room. And that's very, very normal. That's representative of what happens even when I'm asking employment law specialists for their predictions with respect to a very specific scenario. Lawyers have different intuitions informed by different experiences, different cases that loom larger, or cases that they're simply familiar with from their practice for different lawyers. And so using a tool like this, you're able to leverage all of the case law and get a very tight range of a prediction about what a court would do. Now, that's if you're a lawyer. If you are in an HR department, you might be saying, well, Ben, that's very well for the employment lawyers. What does that do for me as a user of Employment Foresight? Well, I think you can really think about this as a few different things. One is it'll lead to a reduced risk of litigation. So if you're able to demonstrate to an employee that you're in the position of terminating, that the award that you are offering them is fair and objectively fair given the state of the case law, that's going to reduce the risk of litigation. So it's a way to make more trustworthy or more objective the amount of notice period that you're going to be offering this person who you're in a position of terminating. You yourself will be able to more confidently determine what that severance package should look like. So you'll be able to leverage a lot of information that otherwise you would have been basically talking to lawyers to hear about it and to learn about it, and relatively inexactly in the past. Finally, even if you don't settle the case immediately, or if the employee doesn't sign that release immediately, it will lead to a reduction in time spent negotiating, because it can clarify the issues that are that there may be some disagreement on in the context of that termination. So it can channel the issues for dispute, and you can really gauge how much that should affect the ultimate settlement amount and the appropriate reasonable notice period at the end. So for HR departments, the benefits are super clear. And I think this is going to be borne out by the illustration, by this case that we're going to run through in the next little while. Okay, so you don't have to just take my word for it. We've got some testimonials here. You know, these are testimonials from a partner at an employment law firm called Cavaluso, Stephen Moreau, really incredibly talented labor and employment lawyer. Once upon a time was a gold medalist from law school, and then went to a clerkship at the Supreme Court of Canada, and is now a partner at Cavaluso. And Stephen made a few different comments. I'm sure you've already maybe read through all of them. I'll just highlight the one on the far right here. He says employment foresight is convenient and quick. It makes the practice more efficient, more accurate. It's a cost saver for the client as well. So you can use these kinds of tools on your own. If you're not using, and if you're an HR professional, if you aren't comfortable, one question for your labor and employment counsel, if you go externally for this kind of help, is, are you using an AI tool to help you figure out these reasonable notice periods? Because it'll make you a more sophisticated consumer of those legal services, and it'll save you money as a client, which is often paramount. Okay, so what does our solution do? Well, the software really makes it easy to understand and strengthen your position in the most common areas of employment law. The subject of this webinar today, of course, is reasonable notice. And that's a question that comes up all the time. How much reasonable notice do I have to give an employee whom I'm terminating? Related issues can come up all the time, though, different kinds of employment law questions. And so we're really guided in what we build into the software by the questions that employment lawyers are telling us, and in-house counsel and HR professionals are telling us that they encounter fairly frequently. So things like, what about drug and alcohol testing? Am I able to test this employee in these circumstances? Is this person exempt from overtime regulations? Do I have cause to dismiss this person? If I do this, is this going to lead to some kind of constructive dismissal clause or constructive dismissal issue with respect to this worker? We want to hire this worker as an independent contractor. Would that be respected? Is that worker actually working as an independent contractor? Can I substantiate that position? As many of you will know, at least here in Ontario, the law has recently changed it to affect the onus on who needs to substantiate whether a worker is actually an independent contractor, and that onus has shifted to the hirer now. And so the worker classification tool in our product is something that you could use to create that record, create that substantiation that someone is in fact an independent contractor. If any issues or questions arise sometime down the road, our focus is going to be on this reasonable notice classifier. How much reasonable notice do I have to give to an employee at the time that I may be terminating them? And we're going to run through a really concrete situation, just so there's a lot of clarity about that thing. Okay, so what you should see on your screen now is a chart with a whole bunch of numbers. What this is a comparison of some of the existing tools that are on the market, not our tools, 4 different tools, tool 1, tool 2, tool 3, tool 4. So we haven't identified what they are. But what we've done is taken 10 recent cases and run the facts of these situations through these different tools to figure out what they would predict with respect to reasonable notice periods. And so in the second column, what you see is the prediction that employment foresight would make about the reasonable notice in these circumstances. In the first column, you see what the court actually awarded. Comparing the employment foresight prediction to what the court actually awarded, you see that we get 9 out of the 10 correct. The one that we missed by half a month. So we said 16.5 to 18 months. The court actually awarded 16 months in that case. Remarkably good track record there. Even when it's wrong, it was correct 90% of the time. When it was wrong, it narrowly missed. What you see in some of the other tools is either they have a very high success rate and a very large range. So that's like comparison tool number 2, a 90% accuracy, which is the same as the employment foresight accuracy, but a really yawning range of prediction over 7 months is the range predicted there. So obviously it becomes a lot easier to predict what a court's going to do as you lengthen that reasonable notice period. Some of the tools that have a very narrow range, like comparator tool number 1, the average range of prediction there is really tight. It's only 0.6 months, but it's right only 40% of the time. So it's more often incorrect than it is correct. So what you see is a mix here of accuracy and reliability, and our tool is the most accurate and most reliable in the bunch by a long shot, which is pretty consistent with our testing. And what makes that possible is we're asking a lot more questions about a particular situation before offering a predicted range. The second thing that makes it possible is we're leveraging super advanced algorithms and a lot of computing power to make the prediction. So we're really crunching the data on hundreds and hundreds and hundreds of cases. We have over 1,000 cases in the database that's driving the AI here. And so we're able to find hidden patterns using AI in making these predictions. So it's super powerful system. And yet the great thing is that it's very easy to use. And I'm going to show you how easy it is to use momentarily. Okay, and we're very accurate, not only in reasonable notice, but also in worker classification and managerial exemption to overtime, drug and alcohol testing. Our kind of touchstone, our target for accuracy in any of these AI tools that we're creating is we try to get to 90% accuracy in out of sample testing, which means if it's a new case that our system hasn't seen before, we really want to be getting at least 90% of those cases right. And we're as high as 95% in some of the classifiers that we're building, which is really, really exciting. When you talk to lawyers who are even active in a lot of these areas, people's intuitions are really quite good given how much data we have to work with. So lawyers do not read thousands of cases in an area before giving an opinion. Nobody has time to do that, and clients don't want to pay a lawyer to read thousands of cases before giving an opinion. Our system is leveraging all the relevant cases before it makes a prediction. And so that's why we're able to get accuracy rates that rival the very, very best lawyers, and in most cases are significantly better than lawyers in the field. Okay, so let's talk about a very specific scenario here. So let's talk about a woman named Laura. So Laura is a 45-year-old lawyer living in Toronto. She's just been dismissed from her employment. She has worked at a big bank for the past 10 years. And in her work at big bank, she specialized in the legal aspects of complicated financial instruments. Unfortunately for Laura, she's being terminated. In terms of Laura's own personal professional background, she went to undergrad, then she went to law school so she went to undergrad for 4 years. She spent another 3 years in law school. After law school, she joined a big law firm in Toronto, and she went to that law firm for 10 years. She worked her way up the ranks and became a partner actually at that firm. And after deciding that it was time for a change, she reached out to a friend, a classmate from law school, reached out to that contact at big bank, and big bank, she worked her way through an interview process at big bank, and big bank hired her. And that was 10 years ago. So basically, she went to undergrad, she went to law school 7 years. She worked at this law firm for 10 years. Then she worked at big bank for 10 years. And now big bank is saying, sorry, we have to terminate you. At the time of her termination, Laura's making $150,000 a year. And she wasn't terminated, at least there's no allegation that she was terminated for performance reasons. Instead, the big bank is saying, well, we have financial difficulties. You've been a good performer. She had just received a bonus a few months before being terminated. But big bank is saying, we have some financial difficulties. We're so worried we're going to have to terminate your employment. So here the question for us is, what reasonable notice period is Laura entitled to? And this is the kind of situation, a very common sort of situation that would arise. Of course, every situation has its own independent special circumstances that arise in that case. So one of the reasons why this is such a frequently revisited area of the law is every situation is a little bit different, a little bit unique. The question is, what do you do with the large constellation of factors that might influence the reasonable notice period that a court would award in trying to do right by Laura and do right by the business? So if you are the professional who's tasked with figuring out how to compensate Laura for the loss of her employment, you don't necessarily just want to offer her the very lowest amount that would be the statutory minimum, for example. You probably want to anticipate, well, what would she be entitled to if this were to go to court, and inform your analysis that way. The challenge is there are so many cases. There are thousands of cases, literally thousands of cases on reasonable notice. And so it's very difficult to really become an expert in what those cases require. But now what you should see, if this is all working properly, is kind of the screen that you would see when you start a classification, when you log into Employment Foresight and select the reasonable notice classifier. You see here on the left-hand bar a number of different questions, different areas of questions that the software is going to ask us, and it's not too onerous, so there are 21 questions here. And so we're going to, as talked about, we're going to do Laura's situation. So I'm going to pick Ontario. It turns out that Laura's employment at Big Bank is subject to the Canada Labour Code. One way to know that is to just hover over this tooltip, and it explains that the Canada Labour Code applies to certain kinds of businesses or industries, including banks. So the very first one is banks. So I can confidently say, yes, it's subject to the Canada Labour Code. Was the worker an employee or dependent contractor of the hire? Yes. So she was an employed lawyer, clearly is an employee. So I can click next here. It's going to continue asking us some questions, and you'll see on the menu bar, we've moved down to worker. So what is the worker's profession or occupation? Well, she's a lawyer. That's pretty easy. And a lawyer is a professional. In her role, she's really performing legal services for Big Bank, so she's a professional. What was the age of the worker at the time of termination? Okay, so I'm going to test your recollection here. Quickly think of it in your mind. 45. If you guess 45, you're right. If you recall 45, you're right. She performed services for the hirer. The hirer here is the bank for 10 years before her termination. So I'm going to say 10 years. She had a total of 20 years of experience. So 10 at the law firm and then 10 at Big Bank. So I can say 20 years of experience. How many years of formal post-secondary education? Well, she had 4 years for her undergraduate training and then a further 3 years for law school. So that makes 7 years. And there's no mention of Laura having any kind of illness or any kind of medical condition that would make it difficult for her to find another position after her termination. So I'm going to answer no to question 2.6. Okay, I'll click next here. Which of the following best describes the business or industry of the hirer? So these are all the usual Stats Canada industries here. Finance, clearly we're talking about a bank. So finance, insurance, real estate, rental, and leasing is the best match. In this circumstance, is it extremely difficult for the worker to find a similar position in this geographic area? Well, we have Laura on these facts working in Toronto, and Toronto has all kinds of banks and financial institutions and law firms. So I'm going to answer no. It would not be extremely difficult. And here, if you have questions about what does it mean for something to be extremely difficult, you can hover over this little information button, and it'll explain how to think about the question. So this gives you a little bit of extra context about the question and why it's being asked and how to think about the answer. So we can click next. And we're already more than halfway done. So we've answered 12 of the 21 questions. We can monitor our progress here. Okay, now we get the question, was the worker induced by the hirer? The answer here is no. Inducement here really relates to, was she headhunted away from the big law firm? So was it that Big Bank went out and really tried to persuade her to leave her job at the law firm and come to work at Big Bank? The answer is no. And in these circumstances, we know from the facts as they're presented to us that Laura reached out to a classmate from law school and approached Big Bank herself, and Big Bank was persuaded that she should be offered a job. So it wasn't the Big Bank going out and really hunting her down and recruiting her into the position. So she was not induced by Big Bank. and she didn't relocate solely for the purpose of working for the hirer. She moved from one office tower down to another office tower just down the block. So here the answer is no, she didn't relocate. She still lives in the same home. Next. Okay, so we do know that she was making $150,000 before she was being terminated at the time of her termination. Here's a question. Was she in a unique and highly specialized position? I think I would be inclined to say yes to this question. She was working on financial instruments, complex financial instruments. So I think that's a unique and highly specialized position. Again, if I'm in doubt, I can look here, and the answer, if I work through that, is yes. And so what we find is that the first few times you work through this kind of questionnaire, it's not super fast, but as you gain facility with the questions and the tool tips and what you can learn from these information buttons, it actually becomes a lot faster, and you can get really confident with how you're presenting things. Question 5.3, did she receive a bonus or promotion for good performance in the prior year? Yes. And had she received a negative performance review or documented formal warning? The answer here is no. Okay, I'll click next. And we're almost done. We just have a few more questions left. Was Laura actively looking for a new position prior to being informed of her termination? No. Was she terminated solely because the bank was in financial difficulty? Well, here the bank is going to say yes. So if I'm answering on behalf of the bank, I'm going to say yes. If I'm answering on behalf of Laura, I might say, well, come on, it's a bank. I'm sure you can make it work. So I'm going to say yes for now. This is one of those questions that we can go back and change the answer to and see how it influences the prediction. And there's no allegation that this termination is for cause at the time of Laura's termination. Okay, so the system's now got all the information that it needs to analyze the situation and give a confident answer about what the reasonable notice period should be that Laura should be entitled to. So I'm going to click compute here, and we're going to get an answer. If you are an HR person or an employment lawyer or someone familiar with this area, try an experiment with me. Jot down on a piece of paper if you have it in front of you, or if you're able to, just mentally commit to a number and just say, okay, this is what I think a court would say about the reasonable notice that would be appropriate in these circumstances for Laura. So just do a test, see how well calibrated you are before we reveal the answer. Because once I reveal the answer, you'll actually suffer from hindsight bias. You'll say, oh yeah, that was obvious. Let's see how obvious it is. So if you're game for it, think of an answer, think it up, write it down, jot it down. If you're watching this with a friend, let's see who can win as between the two of you, who's got the best calibration to what the reasonable notice period should be in this case. Okay, I'm going to click compute now, and I'm not going to do a drum roll because I don't know how, but we'll see what happens here. Okay, so what we see here is that the prediction is 52 to 58 weeks, which translates into 12 to 13 and a half months. Okay, so what the system has done is basically taken all of these facts from Laura's situation, compared them to not only all of the facts of the prior cases that have been decided, but also the results in all of those prior cases. And through machine learning has come up with this prediction saying, okay, based on everything you've told me, Ben, about the situation, about Laura's situation, the most likely range for a reasonable notice period, if this were to go to court, would be a year or just over a year, 12 to 13 and a half months. Okay, one of the cool things here, as I mentioned, is that you can go back and do different kinds of sensitivity tests to see, okay, so what if certain things were different about the situation here? One question would be, what if the worker suffers from an illness or medical affliction that makes it difficult to find another position? I can one click, I can find out, and it'll take all of the facts, change that one fact, and give me a new prediction. What if the employment circumstances in Toronto make it difficult for the worker to find work? I could similarly one click on find out and find out what the result should be there. What if the worker was not in a unique and highly specialized position? I could click that, find out what the result would be. If what you're interested in testing isn't part of this what if dialogue, you can just go back and very easily change it, right? So one example was this question 6.2, where I said, well, maybe if I'm representing Laura, I would say, well, Laura, no, we're not going to actually accept that the bank was in financial difficulty and that's the sole reason you were terminated. So what would happen if we said no to that question? And we can recompute very, very quickly and find out. And what we find out is that it doesn't much matter. So in this circumstance, given everything else, it doesn't actually influence the likely result if this were to go to court. So what I would learn from that, either as Laura or as Big Bank, is I'm not going to hang my hat on that particular argument. I'm not going to invest a lot of time and energy in trying to substantiate, if I'm Big Bank, that we're really in financial difficulty and that's solely the reason why Laura is being terminated. I might just be willing to concede, okay, for the sake of argument, you know, it's a factor for sure, but if you really disagree with that, you know, that's okay. We don't think it really influences what you might be entitled to if this were to go to court. So really cool insight to know that that's not really material in these circumstances. Okay, I can scroll down. This results screen has a lot more information for us. It generates an explanation, a plain text explanation of why the system is making this prediction in these circumstances based on all the case law. So it's explaining a little bit about the Canada Labor Code, talks about the statutory minimum notice, talks generally about the length of the notice period, and describes what you're going to see a little bit lower with respect to similar cases. So this is the next really helpful part of this process, where we actually get visibility into the most similar cases that have been decided before by the court. So here, really, really amazing. So if you're representing a big bank, or you're trying to figure this out from Big Bank's perspective, you might be really interested in the most similar cases that had similar facts, but shorter notice periods than that predicted by employment foresight. And if at a glance, you're hoping to see what was similar and what was dissimilar about this particular case, you can just hover over the similarity bar and it'll tell you, these are the similar factors, these are the dissimilar factors. And so without necessarily reading the case, you can at a glance get a very good idea about what's happening here. Okay, now, what else can I do here? Well, if I'm interested in the longer cases, so suppose I'm doing a little bit of research into Laura's situation, and I want to know about the longer cases. Here I can find the most similar cases with the longer notice period, and so I can go and see what factors are similar and dissimilar in those cases. What this all has in common, though, is that these are the most similar cases to Laura's situation, and so at a glance you can see these 20 most similar cases, and the system finds them for you and surfaces them for you and tells you precisely what's similar and dissimilar about all of these cases. So you can really be confident, drill down. If you want to drill down even further, you can just click on the case, and it'll take you either out to Canley or to other databases where you can read the full text of the judgment. If you really want to geek out and read the judgments. For some people, that's something that they really like to do, and it makes them feel a lot more comfortable about the situation before they know how they want to proceed. Others are more comfortable finding out what the system's predicting, and then working from there through their own mind and their own considerations. One of the things that's often very helpful is downloading a PDF report of this. So if you want something that's really nicely formatted that you can add to an employee's file, for example, when you're terminating them, you might want to save this PDF to their personnel file. If you're a lawyer representing either a dismissed person or the company, you can find this very helpful in substantiating terms of settlement, facilitating that conversation about what should actually be offered in those circumstances. So this is a one-click download, automatically generated by the system. Very, very easy to produce and to use. Okay, let's hop back into the presentation for a moment. And let's do some other scenario testing. So how do you think the reasonable notice period would change if Laura's compensation was $300,000 a year rather than $150,000? Do you think that would affect the situation at all? Okay, so what I'm going to do is hop in here. Okay, so she's at 150. What happens if we change that to $300,000? First of all, what's your intuition? What do you think should happen? You might think, oh, it shouldn't matter, or you might think, oh, well, if she's earning more, maybe it should lengthen the period because it's going to be that much harder to find a comparable position. Let's see which of those two intuitions is right. It doesn't matter, or it does matter. And if it does matter, how much does it matter? This really can affect the payout because we're talking about not only the amounts that she should be paid per month for that notice, but also the length of the notice period. So there's a multiplier effect if it does actually lengthen the period that you're going to want to know about. Okay, let's see here. Okay, so it does lengthen it, and it shifts the entire range up by 1.5 months. So that's a pretty significant change here because we basically doubled her comp and then we've increased the predicted range by 1.5 months. So that's pretty significant. And what happens if we change her compensation to $50,000? So remember, we started at 150 and it was 12 to 13.5 months. Then we increased her comp to 300K. And that increased it to 13.5 to 15 months. Now we've reduced it to $50,000, and let's see if that cuts it back. I'm curious here. Okay, it does a little bit. So doesn't move it back as much as the step from 150 to $300,000 shifts it up by 6 weeks. The shift from 150 down to 50 reduces it by 1.5 months at the high end, but just a month at the low end. So the system is calibrating to a bunch of different factors and even influences the length of the range because it's selecting the range in a way that's sensitive to the facts that we're introducing to the system. Okay, what about inducement? So this is that question about, was Laura headhunted? Let's find out how much that matters. So if Laura was headhunted, so I click on inducement, how is that going to influence the payoff here? Well, for how many years did Laura perform services for her previous employer? For 10 years for the previous employer before she was induced by the hirer. Okay, so that makes sense. It's basically trying to contextualize what Laura was giving up before she was recruited away from that job by Big Bank. Let me just make sure I changed this number back to $150,000. Okay, so yes, we're saying yes, inducement now, and she worked for 10 years at her previous employer and now 10 years at Big Bank. And remember, the range with no inducement was 12 to 13.5 months. What happens now where we say, yes, there was inducement? So when we run through this situation with employment lawyers, we sometimes, again, get two different responses. One response is, yeah, inducement should matter, but an inducement away from a 10-year career, that's really significant, but maybe it should be attenuated a little bit because she's been at Big Bank for so long. So it's not like she was giving up a 10-year job and then she was just at Big Bank for a year. She's giving up a 10-year position at the law firm, and then she's been at Big Bank for 10 years. And so some employment lawyers start with, yes, it's really significant, and then you should maybe discount it a little bit because of that length of tenure at Big Bank. Others say, oh, it's irrelevant after 10 years. It should have no difference whatsoever on the notice period that she should be entitled to. So let's see which one is actually consistent with what judges do in court. So we'll click recompute. And we find out that it actually has no influence. So the predicted influence in this circumstance, given everything else, is that it wouldn't actually have an effect. So like the financial difficulty question, this question about whether there was inducement or not inducement doesn't matter. It's not worth fighting over. It's not going to influence powerfully what a court would do. And almost all circumstances here. Okay, so let's hop back here. Oh, this third one is pretty interesting, right? So let's keep all the facts the same, but let's just say that Laura played professional soccer for 10 years before attending law school. So all this is changing on these facts, right, is that Laura is going to be 10 years older because the rest of her career is exactly the same. So instead of being 45, she's going to be 55. Let's see how that influences the results here. Okay, so I'm going to jump back here and we'll click on the worker because I think this is where we confronted that question. So yeah, what was the age of the worker at the time of her termination? She was 55. And I should go back and make sure that I change this inducement thing. So there was no inducement. So we're back to the baseline where there's no inducement. But now she's 55 instead of 45. The rest of the facts remain entirely the same. So this is interesting because this is just shifting her career from starting when she was 25 to starting when she was 35. Okay, let's see what happens. My intuition would be that it should maybe increase the reasonable notice period a little bit because she might encounter a little bit more friction in the labor market. She's going to be a little bit older when she's trying to find a replacement position. All else the same, that might influence things. But let's see what judges actually do in these cases. It's better to make data-driven decisions than intuitive ones. Yeah, and that's right. So it is right that she would be entitled to a little bit extra notice here, 13.5 to 15 months. Again, it shifted it up by about a 6-week period. Okay, so you'll see this is a really powerful system. It's really easy to use. It asks you 21 questions here. In some circumstances, up to 23 or 24. Sometimes there are dependencies, so it might ask follow-up questions. As we saw with inducement. So if you say yes to the inducement question, it asks a follow-up question, which was, okay, the position that she had with her previous employer, how long was she there? And because the system just needs a little bit of extra information to give an accurate prediction about what that means for this situation. But what you can see is if you are an HR professional, this would very, very quickly give you a sense of the lay of the land in terms of what courts are doing in these circumstances. It gives you the power to analyze a big chunk of data and to follow up. If you are particularly nerdy and you want to go and read some of the cases, you can also go and read some of those cases and satisfy yourself about this. It can also make you a more sophisticated consumer of professional services. So if you do have the habit of asking employment lawyers for advice in these kinds of matters, one question you can ask is, are you using an AI tool to influence what you're telling me? Because I understand that there are these AI tools out there that are really powerful that can help you reduce the cost to me of the legal advice that you're giving to me. Or it could also serve as a bit of a triage tool for you. So you might say, okay, if I'm comfortable using a tool like this, I can use this tool only in really the most tricky cases. Am I going to go to external counsel? I can probably figure it out on my own, leveraging these kinds of research tools. Okay, so we've got a number of minutes left, about 10 minutes left here, and I've got a bunch of questions that are pouring in through the Q&A system here. Okay, so so one question was, how would the employer know whether Laura was actively looking for another job? Great question. So this is kind of tricky, right? So let's go back, and one cool thing to find out is, let's just change this back to the baseline. So 45 years at the age of termination. And now we've got the question about, was she actively looking for a new position prior to being informed of his or her termination? Let's just see what is the influence of that. So remember, the baseline here is 12 to 13.5 months. What if she was looking for a new position prior to being informed of her termination? What should the influence of that be? So one response to this question is, how would the employer know? Sometimes they could find out. Sometimes it's more difficult to find out. Maybe it's a question for Laura, for the other side, if some kind of dispute arises. But let's see if it actually influences Laura would be entitled to in these circumstances. So it doesn't actually influence the results. So in some cases it does, right? So if we're asking these questions, it's because in some collection of facts, in some circumstances, it really does matter. One of the really powerful things about this approach to looking at this question is you can find out how much it matters in this particular situation. And so here, if I were using this tool to figure out what to do about Laura, I might say, okay, it actually doesn't really matter very much how I respond to that question about whether Laura was actively looking. Okay, somebody else has asked, if you drop the salary drastically, wouldn't you have to change the status from professional to less of a role? You could do. I mean, I think this is a little bit unrealistic in these circumstances. I don't know of a lawyer with 20 years of experience working on complex things at big banks that are making $50,000. But let's see how much that changes things. So so we've got here professional. We can just say other here, or maybe, yeah, other. You can say other. What was the other one that I changed? Oh, was she actively looking? So let's change that back to no. Okay, so I think what I've done is I've changed it to 50, and everything else should be the same, except for I also changed that label of worker down to other rather than professional. It might make a difference. So the baseline here, if I remember right, was 11 to 12 months. No, it doesn't make a difference. So it's not being driven by that professional label in these circumstances. Okay, so we'll change that. Let's change this back. Let's change all these things back to our baseline scenario, 150. Okay, would you please change the applicable law just to see the effect? Okay, this is a good question. So let's make sure I've got the baseline properly specified here. So it should be 12 to 13 and a half months if I successfully identified all those things. Yeah, okay. Would you please change the applicable law just to see the effect? Okay, so yeah, so different provinces actually have different attitudes towards this sort of thing. So let's try Alberta. Let's see if changing to Alberta changes things at all here. It does. So in Alberta, it looks like she would be entitled to a shorter notice period from 12 to 13 and a half months to 11 to 12 months. So it looks like the Albertan courts in situations like this would offer slightly less notice than do the Ontario courts. I'm just curious. I'm going to switch this now to Quebec and see if there's any difference in Quebec from Ontario. And I guess Alberta as well. Okay, it looks like Quebec generates the same result here. Okay. What if she has gainful employment during the entitlement period? Does this make a difference in the future? Yeah, so this question, that's a good question. That's an employment law question. Here, the question is, what would the reasonable notice be that she would be entitled to if she, if it were just to go to court at the time that she's being terminated? Oftentimes, if there is mitigation on the part of the employee that's going to influence what a court does, it'll probably affect what the court actually decides at the end. So yes, that's a great question. Yeah, of course that would be relevant as well. Okay. Okay, yeah, there's some questions now about the scope of the termination. So what happens if you're actually terminating many people all at once? Yes, there are considerations that apply. If you're in kind of a mass termination situation, there are different rules that kick in some circumstances, and so some of that may be addressed here in this explanation. Okay, so it could be that there may be some exceptions under the code here. And yeah, so if you're in doubt, obviously the system's not providing legal advice. This is providing information on, the case law that's out there and how to synthesize that case law. So it's really getting into the computational legal research realm. And of course, this isn't the end of the story. So where we see this being used now is by a lot of labor and employment lawyers who are very, very familiar with the relevant statutory authorities. They're familiar with many of the cases, but nobody is familiar. At least I have talked to nobody who says, yes, I know all the cases in this area. And so they don't know all the cases. And this is a really great way to validate their instincts, get backup, and help equip themselves for that settlement conversation with the employment lawyer on the other side of the dispute. So this is not providing legal advice. This is a legal research tool that you can use to inform yourself about what the cases would actually require if this were to go to court. So that's one thing. And the other thing is this is really, really designed to be easy to use, leverage all of the cases. But if you're at all unsure, you should seek legal counsel and get legal advice. This can help you figure out which lawyer to use. So you can ask the question, are you using employment foresight or other kinds of AI solutions to inform the advice you're giving to me, to make it faster for you to actually provide the advice, and also give me some comfort that you're leveraging all of the case law and formulating your opinion. So that's something that you can ask. And also just to get a sense of how well calibrated your counsel are. One cool exercise that you can actually run through, and I'm often asked to do this when I approach folks, even like socially. People say, "Oh, a friend of mine was just terminated. Can we run her situation through the system and just see if she got a fair package?" Or if it's someone in management, they say, "Oh, I just had this this employee that I terminated. Did I do the right thing in giving that employee a year's notice or something?" And so you can actually just very quickly do back testing on what you've done in the past and compare it to what the courts would have done, which is actually really helpful in figuring out if you've been doing the right thing. Okay, so somebody's asking, can you identify the exact name of the judge in each case? So one of the things you can do here is you can also go to the case finder. So the case finder, and I haven't showed you this, but you can find cases by lots of different attributes of those cases. So either by the citation, by the length of the notice period, by the particular court, if you know the court that you're appearing before, that would be applying, kind of the timing. And a lot of the case finders, you can also search by the name of the judge who decided the case. You can find all the Judge X cases, for example, which would be very, very helpful in a lot of circumstances. You can, of course, also load the cases, right? So if we go back, I can conveniently pull up from my history the facts here. And what I will do is reload one of these things, and then I will click on one of the cases, and you can see immediately the name of the judge who decided the case. So I'm just reloading this, recomputing it, and then I'll go down to the most similar cases, and I can see, okay, who was the judge in this particular case. Turns out it was Justice Stewart in this case, and I can go and read the full text of this case, which happens to involve KPMG. Okay, so we're at the hour. It's been really a ton of fun running through employment foresight with you. I hope you understand better how you can use employment foresight to get insight into what the law requires in your particular situation. I do apologize for some of the technical difficulties that we had. Again, this is unprecedented with my use of this software with Zoom. I hope it was just a weird aberration. But thank you very much, and enjoy the rest of this sunny day if you're somewhere sunny. All the best. Take care.